So what should be included in a durable power of attorney? I'm going to start off by saying this video is in no way meant to be an exhaustive list of what should be included in a durable power of attorney. Rather, it's just a few things that have come up recently in my practice where people did not have specific language in their durable power of attorney, and it ended up being very problematic for them. So example one happened when a client came to me wanting to make sure that his mom's house could pass to him and his siblings when his mom passed away without needing to go through probate, which can oftentimes be very lengthy and expensive. So this particular client had or was listed as the agent on mom's durable power of attorney. Mom was in the end stages of her life. She was under hospice, not doing well, under lots of pain management, and definitely did not have the capacity to sign the deed herself. No problem, right? He's durable power of attorney, and his durable power of attorney included the very standard general section on real estate transactions. But it was missing language specific to ladybird deeds, where property is being given to beneficiaries. Similarly to adding a beneficiary on a bank account or another account, a ladybird deed in Florida is what allows you to list one or more people essentially as beneficiaries, transfer on death recipients for your real property in Florida. There are title insurance companies who look for this specific language. Why is this important? Well, when you go to sell the property, if the plan isn't to keep mom's home, but it's going to be sold and the proceeds divided between the siblings, you want to make sure that the ladybird deed is accepted by the title insurance company who's handling the transaction. Oftentimes, they're very particular about what they look for. And I have actually run into title insurers who will not accept ladybird deeds signed by somebody other than the owner of the property, meaning they were signed by the agent under the power of attorney when that specific power was not given to the agent. And what I mean by that specific power is that they could actually sign on behalf of the principal, the person who created the power of attorney. They could sign a ladybird deed on their behalf. So you might want to double check to make sure that's in there. Another thing that was probably even more important in this scenario, and I have seen this play out not so well in different types of scenarios, is there also wasn't a paragraph that was initialed by the mom that stated it was okay for her agent to make gifts, including gifts to the agent. Why is this important? So if you're trying to execute something like a deed on your mom's behalf, you may be able to do that if the power of attorney, one, gives you the power to execute the deed, and two, if you're going to be one of the people listed on the deed who's going to be receiving the property, it also has to give you the power to make gifts to yourself. Now, I have seen some power of attorneys where the agent can make gifts to others, or the agent can add beneficiaries to accounts. However, if the agent, and this is often the case, is a child or somebody who the person who created the power of attorney would want to leave their property to, like a child, or, in an instance, maybe a close friend where they don't have any children. If it's somebody who they would naturally want to leave something like a bank account or their home to, well, you've got to make sure that they're actually permitted to give gifts to themselves. I'm sure you can understand that a bank might have an issue accepting a beneficiary on an account when it was that person themselves who added themselves to the account, right? Or especially in this instance, again, a title insurer is probably going to have a big issue allowing property to pass directly to someone who actually signed the deed themselves, right? Looks like there can be a little bit of self-dealing involved, right? Like, sure, I'm just going to go ahead and add myself as beneficiary on all the accounts before my mom passes away. So these are commonly two things that I see being left out. Now, maybe there's certain instances where you do want to leave them out. Maybe the agent who you picked isn't someone who you want to have listed on your accounts as a beneficiary, but more they're like a separate third party who you trust them to list your children or other people on these accounts, then fine. But I see more scenarios when it's a child who's acting as the agent under the power of attorney for a parent, and it's that child themselves who the parent wants to have their assets, or at least split the assets with maybe the other children. And if you don't have a provision in there that specifically allows that child to gift your assets, and including gifting the assets to themselves, then they can run into a problem which either leaves them without their share or which requires a probate. And the last thing I'm going to touch on in this video, again, there's many, many more. I could go on for days about clauses that should be in durable power of attorneys. But another thing that I'm going to touch on, because this came up today in my practice, is not having an elder law who drafts your documents, so you don't have a section in there for assistance with government benefits or assistance with Medicaid. Our office often gets people qualified for Medicaid even at the last minute and not run any risk of violating Medicaid's 5-year look-back period by being able to set up qualified income trust, Miller Trust, where we can transfer excess income of the Medicaid applicant into a trust account so it doesn't count against them for Medicaid qualification, or things like pool trust so we can transfer assets, again, so the assets don't count against them. And oftentimes personal services contracts, which are typically entered into between the Medicaid applicant and a child or children or spouse in order to, again, transfer assets out of the applicant's name so they could qualify for Medicaid. A lot of this planning is done sort of last minute or an emergency when someone's in rehab and needs to quickly be able to qualify for Medicaid. If your durable power of attorney doesn't have a section that allows your agent to enter into these agreements on your behalf, to sign off on the Medicaid application, to apply for benefits on your behalf, then you run the risk of not being able to qualify, especially if you're in a situation if you don't have the capacity to sign these documents yourself. So this is just a few things that I see really commonly in practice, which is why I wanted to bring them up. But ultimately, it is a really important reminder as to why you should have your durable power of attorney prepared by a qualified estate planning attorney who also practices in the area of elder law. Durable power of attorneys that are 2 pages, 4 pages, it's a gamble. What you need might be in there, most likely it isn't, and you don't want to be in a situation where years down the road you need something and it was left out. So you definitely want a qualified professional. Our power of attorney is a 30-page document. It's a 30-page document for a reason. So you want someone who can at least sit down with you and explain the pros and cons of having these things in your power of attorney. If somebody's not telling you why you would need something or why you might want to keep something or not have something, then you're not getting proper advice, and it can end up in a very costly mistake down the road. All right, so I hope this helps. If there's any questions about durable power of attorneys or other documents commonly included in the estate plan, please leave it in the comments. If you like this video, please click the like button. And if you have any other questions about estate planning, Medicaid, elder law in general, and you're in Florida, please don't hesitate to reach out to our office. We're at Cause Law Office, the non-stuffy attorneys, and the link is in my bio.